Justices. I appear for the first respondent in this matter. Advocate Nadia Badat, and I appear for the first respondent in this matter.
Is there a problem with connection?
Does seem to be.
Yes.
Chief Justice, Ms. Badat has placed herself on record for the first respondent. I'm not sure if you were able to hear that.
Looks like the Chief Justice can't hear us.
Yes. Are we ready? I had disconnected. Ms. Badat, I take it that you've introduced yourself already.
I have indeed, Chief Justice.
Thank you very much. Mr. Bartlender, over to you.
Thank you, Chief Justice. Members of the court, as we know, under apartheid, the law discriminated against married African women in respect of matrimonial property. It discriminated against them on two grounds. First, it discriminated against them because they were women, because they were men, their husbands were given ownership and control of the family assets. And second, it discriminated against them because they were African, because it was only African women who were disadvantaged in this way. We've referred the court to the passage from the well-known book by Professor Harlow on the South African law of husband and wife, which explains that community of property was the default position in South African law under the common law, and still is. Well, eventually the statutes were amended, and African women who married were no longer treated in this manner. But each time the law was amended, it left out of account those women who were already married under this discriminatory regime. They remained, and they remained subject to the discriminatory regime. And this case is the third of a trilogy of cases, and I hope the last of that trilogy, last of that series, to come before this court in order to address that problem. Members of the court will recall that the first case was Gumede. Ms. Gumede and her husband were in a monogamous customary marriage, which was subject to the KwaZulu Act on the Code of Zulu Law and the Natal Code of Zulu Law. And this court explained that the effect of those laws was that Ms. Gumede had no rights to the family property, either during the marriage or on dissolution of the marriage. And the court said that this was, to use the court's word, obviously unfair discrimination against women. In 1998, the Recognition of Customary Marriages Act removed the discrimination. It said that the default position for African women in customary marriages would be a marriage in community of property. But the Recognition Act didn't apply to existing customary marriages. Ms. Gumede and many others continued to suffer the unlawful discrimination. This court in the Gumede case struck that down. It removed those words entered into after the commencement of the Act to provide the protection of the Recognition Act to all women married in customary marriages, but only in monogamous customary marriages, because that was the issue before the court. The second case was Ramuhovi, when the court extended that principle to women married in polygamous customary marriages. And so this case, Sithole, is the third. Ms. Sithole and Mr. Sithole entered into a civil marriage in 1972. The marriage was governed by the notorious Native Administration Act of 1927, one of the pillars of apartheid. This court in the DVB Behuising case, in paragraph 1 of DVB Behuising, described this act as, quote, an egregious apartheid law, which anachronistically has survived our transition to a non-racial democracy, close quote, close quote. That act still governs Ms. Sithole's marriage in 2020. The Native Administration Act made marriage out of community of property the default position for civil marriages, such as those of Ms. and Mr. Sithole. In other words, it created the same discrimination as the court struck down in Gumede and Ramohovi. Section 22.6, which is the offending section of the Native Administration Act, was finally repealed in 1988, but it too perpetuated the existing discriminatory matrimonial property regime through the Matrimonial Property Act. And so
Mr. Bantlender, can you please indulge me? I was looking through your heads. I thought that the case that you had referred to, I would see it in your heads, but it's not here. Can you just please help me with this full citation?
Thank you, Justice. The first case was Gumede.
No, I think it's DVB.
Oh, DVB Behuising.
Yes, Behuising, yes.
I apologize. I don't have that. Can I give that reference to when I reply, Justice?
Okay, all right. Okay, I've got the reference to Gumede.
Thank you, Justice.
Thank you.
So as we say, the Matrimonial Property Act perpetuated the unfair discrimination in existing civil marriages, exactly the same problem as in Gumede and Ramohovi. And we say that as in Gumede and Ramohovi, the perpetuation of unfair discrimination ought to be struck down. The discriminatory nature is set out in our heads of argument. I'm not going to read them. It's paragraphs 46 to 50 of our heads of argument. But I do want to show you, the members of the court, how this worked and has worked and continues to work in practice for Ms. Sithole. If members of the court would care to go to volume 1 of the record, page 11, Ms. Sithole explains what has happened to her as a consequence of this. At page 11, paragraph 22, she says the following. She says, between 1972 and 1985, I stayed at home and raised our family. We have 4 children, all of whom are now adults. I conducted my own home-based business selling clothing. Most of my earnings helped to pay for the education of our children in private schools. The remainder of the funds were utilized on the family and household expenses. In 1985, I commenced formal employment as a project manager at an engineering firm, but continued operating my clothing business. All of my income was used to pay for the education, including tertiary education, of our children and for our family and household expenses. My contributions to the family and its expenses led directly and indirectly to the increase in the value of my husband's estate. In paragraph 24, our family home was acquired in 2000, in other words, during the marriage, and it became the property and the sole property of her husband. And over the page, in paragraph 28, she tells the court that her husband then threatened to evict her from the house, which is not denied. She says, paragraph 28, my husband's threats to sell the house continued. As a consequence, I brought proceedings to interdict him from selling our home. I could not allow this to happen for 2 reasons. First, it is my home and selling it would render me homeless. Second of all,
Mr. Badlander, to what extent is the actual financial contribution to the estate relevant to the question of validity? I'm asking this in particular, taking into account the fact that Mr. Sithole is saying what contribution there could have been is negligible or it's not even there, basically, because he says what she says she sold and all that, he basically saw nothing of that. To what extent is any of that relevant?
It's strictly speaking, it's legally irrelevant, Justice Matlanga, because she contributed to the family. The famous phrase that is used in this situation is that what the woman does is unpaid labor. She classically looks after the family home, looks after the family. She earns, nothing is earned for that. The paid labor is performed by the husband, and then he says, well, all of that is mine. So what the earnings are strictly speaking irrelevant. This case illustrates that even when there are earnings, doesn't assist the wife. And she says in paragraph 28.2 that if he sells the house as he's threatening to do, it will rob me of an asset that, but for the discriminatory laws in place at the time of our marriage and continuing thereafter, would have been registered jointly in our names, or at the very least would have fallen into our joint estate. And she points out that she obtained an interdict from the High Court preventing the sale of the family home pending the outcome of this constitutional challenge. If her challenge fails, he will sell the home. She will be left homeless and propertyless. So those are the facts of the matter. And the minister rightly doesn't deny that this is discriminatory and unfairly discriminatory. Mr. Sithole, however, also doesn't deny that the system is in general discriminatory. But he says he's got three defenses to the claim raised by Ms. Sithole. The first defense, he says, is that he and she knew and agreed when they married that their marriage would be out of community of property. She says that's not true. She says she was shocked to discover that they were married out of community of property, and she only discovered it when the present disputes arose. But the dispute of fact in this regard is, we submit, irrelevant, because Ms. Sithole and the Commission for Gender Equality challenged the validity of sections 21.1 and 21.2a of the Matrimonial Property Act. They say that it discriminates unfairly, and we submit that it can't be disputed that it discriminates unfairly, and that can't be affected by whatever discussions Mr. and Ms. Sithole did have or didn't have in 1972 when they were married. It's either discriminatory or it's not discriminatory. And the second applicant, the Commission for Gender Equality, explains in its founding affidavit, I'm not going to take well, perhaps I can take the court there briefly. It's page 39 of the papers. Page 38, I beg your pardon, paragraph 11, where the CGE refers to their experience and to their research. They refer in particular to a case known as Z, which took place in KwaZulu-Natal and in Pietermaritzburg High Court. Then they say, paragraph 11, my respectful submissions on the above case are as follows. One, it's not a rare occurrence for persons married under the Black Administration Act to wrongly assume that their marriage is in community of property. After all, that is the default position for other women married in South Africa. Secondly, the insertion of section 21.2a.2 in the Matrimonial Property Act in 1988, giving the option to persons such as Mrs. Z to change their matrimonial property regime by registering a notarial contract, was a dead letter. There's no evidence, according to our research, that shows that affected persons used this law to change their matrimonial property regime. They say then over the page, if section 21.2a.2 had declared the marriage in community of property, subject to the right to opt out, it would have dealt with the negative impact of section 22.6 of the BAA, and they say it would have afforded relief to thousands of elderly women across the country. Members of the court may have seen the evidence. The expert evidence is that there are 400,000 women who are in this position and who are affected by this case. And then they say Mrs. Z would have had the protection of section 15.2c of the Matrimonial Property Act, which deals with insurance policies. And then they say instead, we now have a situation where Mrs. Z and women in similar positions are condemned to poverty. They say, I submit that section 21.1 and 21.2a of the Matrimonial Property Act have failed to bring any real, effective or meaningful relief to this category of persons. Rather, they maintain the positions set by section 22.6 of the Black Administration Act and perpetuate its discriminatory effect on Black women. So we say that Mr. Sithole's allegations are...
But Linda, I think before you proceed, it is only fair if I just clarify this in my head, because what I'm struggling with is on what grounds is the Matrimonial Property Act discriminatory? I accept that on race, it is discriminatory and that discrimination is unfair. But when I read the papers, and there's reference to women. I accept what you said that in the past, women property belonged to their husbands, then the husbands had the control of the property. But the Matrimonial Property Act, can it really be said that it discriminates against women?
Justice, yes, it discriminates against women because it perpetuates the existing discriminatory regime in respect of marriages concluded before 1988, and it discriminates against women because the effect of it is that the men continue to have ownership and control of all of the property. So that's the discrimination against the women. It puts the property in the hands of the men. Justice, it's what there's now a very fashionable term about intersecting grounds or intersectionality in grounds of discrimination. This is a classic case of intersectionality. It discriminates against African women married before 1988. They have no control over the family property.
Let me just explain where my question comes from. I accept that a majority of African women do not own property. I accept that a majority of African women are not employed, but there are those African women who are employed and who own property, and their husbands are either own less property or do not own property. I'm just worried about the risk of this court making a blanket statement that in fact the Matrimonial Property Act today, as we are deciding this matter, also discriminates on the basis of gender. I'm with you concerning race. And as I was looking at the papers, I even thought that maybe there could be discrimination on the basis of age, because the women who are bound by this are women who actually got married before 1988. But I'm just concerned about the general statement that this discriminates against women, or this is discrimination on the basis of gender.
Yes, well, it discriminates justice on the ground. The women in this class, African women married before 1988 in a civil marriage, are governed by Section 21(2) of the Matrimonial Property Act, which has the effect that the marriage continues to be out of community of property unless they enter into a notarial contract and register it within 2 years. And so we say that discriminates against them as women, because whatever property, whatever work they've done, whatever property they have earned or collected, and whatever work they've done, paid or unpaid, the product of all of that belongs to the husband, because the marriage is out of community of property and it all accrues to his estate. They were also subject at that time, of course, to the marital power, which aggravated the position. But the property all accrued, and that's accrued to his estate. And that's what this court found in Ramahovi and in Gumede, that under the customary law, the marriage all accrued to the estate of the husband, and he became the owner and controller of the property. And that's why, as matters presently stand, Mr. Sithole can go off. If he didn't have the interdict against him, he could go off today and sell that family house, which was acquired during the family marriage, and Ms. Sithole would be left with nothing. And that's for 2 reasons. It's because she's an African. 3 reasons. It's because she's an African. It's because she's a woman. She therefore loses the family property. And it's because she was married before 1988. And as you've pointed out, Justice, there's also an age discrimination element in this.
Mr. Butlender, the Section 21(2) route, also the other problem would be one would have to have the funds to go and get assistance to do this, to convert from out of community of property to in community of property. And what about those who are not even aware of that Section 21(2) route? How would they be in a position? How would they be protected?
Yes, Justice Mhlahla, there are three obstacles to exercising that protection. Firstly, as you said, Justice, you have to know about it. Secondly, you have to have the resources to do what is necessary, the financial resources. Thirdly, you've got to have the consent of your husband. You can't do it unilaterally. If he says, no, I like the fact that the property is all mine, well, that's the end of the matter. You can't exercise that power at all. So the discrimination is perpetuated in a large number of cases.
Mr. Butlander, please, can I understand what the applicant's case is? The High Court, in paragraph 1 of the order that it granted, paragraph 75.1, on page 342 of the record.
Yes, Justice Troy.
The provisions of section 21(2)(a) of the Matrimonial Property Act be and are hereby declared unconstitutional. Now, in the written submissions of the applicant, Mr. Butlander, at page 6, paragraph 17, it is stated that the High Court declared sections 21(1) and 21(2)(a) of the Matrimonial Property Act invalid and unconstitutional. Yet the declarator from the High Court was only in respect of section 21(2)(a). The relief that the applicants are seeking, according to the written submissions in paragraph 108, page 41 of the applicant's written submissions, is the matter now before this court is whether the order made by the High Court should be confirmed. Can you clarify, Mr. Butlander?
Yes, Justice Turan, I think the reference to section 21(1) is superfluous. It doesn't assist because it's 21(1) says a husband and wife, whether married before or after the commencement of the act, may jointly apply to the court for leave to change the matrimonial property system, including the marital power, which applies to their marriage. And that doesn't discriminate against anybody. That doesn't discriminate against African women or against women. It's an even-handed provision. And so the reference to 21(1) with respect is incorrect.
Thank you.
So if I understand it correctly, Mr. Butlander, this reference to section 21(1), that actually, it doesn't take the matter anyway. All you need is for the High Court order in respect of 21(2)(a) of the MPA to be confirmed. And
that is so, Justice Wade.
Yes, yes. Thank you.
I apologize for that. That's my error.
So, Mr. Butlander, where? Yes, Mr. Butlander.
Yes, I'm here. I'm sorry, I can't hear. Am I being addressed?
Well,
Yes,
I think there's a connection problem, Mr. Butlander.
I can hear now.
My sister Kampepe was. Yes. I think it was Justice Kampepe.
Yes, Mr. Butlander, I'm back with you. And I'm sorry, there was a technical glitch on my side. So should we accept it that where you say at paragraph 93 of your heads of argument that you seek confirmation of the declaration that section 21 be declared invalid, that should be disregarded?
Yes, it should be, Justice Kampepe. I apologize for that.
Okay, fine, thank you.
So there's the point we need to make it, and really the fundamental point. Well, so can I say this? So the first offense of Mr. Sithole that he and his wife agreed doesn't address the unconstitutionality of the marriage, of the statute. The second offense he raises is the point which we've just been discussing, which is the possibility of a notarial contract. And Justice Mhlahla has pointed out that that's not an effective defense either, because you've got to know about the provision, you've got to have the resources to go to court or to file a notarial contract, and most fundamentally, you've got to have the agreement of your husband, because it can only be done by consent. And then the third defense that is raised is a defense that the divorce court can remedy the situation when it makes a divorce order. But this court, that was raised in this court in the Gumede case. The same defense was raised. And the court said in Gumede that that is plainly no answer. It's of the reported judgments in the South African Law Reports, paragraph 13, page 159, the court said the following. I've got the wrong passage, I beg your pardon. The court, anyway, the court rejected the argument. It said that, it's paragraph 45. The court says, it is so that Mrs. Gumede could have approached the divorce court requiring it to make an order that is just and equitable in relation to the marriage property. That, however, is no answer to or justification for the unfair discrimination based on the listed ground of gender. It goes on, it says it applies only to dissolution of the marriage. It doesn't cure the discrimination which the spouse in a customary marriage has to endure during the course of the marriage. And it goes that there's a full, it's dealt with fully in paragraph 45, and that defense is rejected roundly by this court in Gumede. Finally, on this question of these defenses, I need to refer briefly to the affidavit of Father Mdabe, which was filed at this court this past week. It's a late affidavit which was filed without any authority, but leaving aside the impermissibility of doing this, it's entirely irrelevant with respect. It's an attempt to prove that in 1972, Mr. and Ms. Sithole knew that they were entering into a marriage out of community and deliberately chose that. But how Father Mdabe, who became a Catholic priest in 1989, knows what happened in Mr. and Ms. Sithole's marriage in 1972 is never explained to the court. In any event, even if they had agreed, it's irrelevant to the validity of the law, to the constitutional challenge. It could be relevant to remedy, and that's what I'd like to come to now. So we say, as far as remedy is concerned, that the starting point is the principle of objective.
I'm sorry to interrupt you, Mr. Badlander, but just to perhaps build on the question that was posed by Justice Chikwi, and that it may link also to remedy. If this court grants an order that all marriages concluded out of community or property under section 22(6) of the Black Administration Act are now marriages in community of property, would that not result in women who have acquired property over the course of their marriage losing their interest or their half share in that property? In other words, the declaration could cut both ways, in that it will not always be the case that women will benefit from this order, or that all women will benefit from this order. What do you say to that?
Justice Ron, first I have to express doubt as to whether women married under this regime could legally acquire property. They were subject to the marital power, and they were in a marriage in community out of community of property, and the property, I submit, actually fell into the husband's estate. But whether or not that's so, what we propose in the remedy is a provision which will enable this to be cases of individual cases of injustice to be addressed. And that's because we do accept that one needs to get, basically what one has to do is get the basic rule right, which is equality in marriage, no default position of marriage in out of community of property, because that's a provision which creates inequality in marriage. Then one needs, in the remedial provisions, to make it possible for adjustments to be made in individual cases. And that's what I'd like to address now, if I may. So we say—
Linda, can you please assist me? Sorry. When marital power was abolished, is your submission that even though it was abolished, women then could not have property in their names?
No, Justice, once the marital power was abolished, they could have property in their names.
This is
But it was
where I
not-
was coming from.
Yes.
Because if then marital power was abolished, and then you find a situation, and I'm sorry if I'm belaboring the point, because I'm just worried that I don't want us to declare it on a ground that is not competent. Once marital power was abolished and these marriages were out of community of property, and you have that rare case, and I agree it's rare instances, where then the woman is stronger economically and otherwise than the man, then that woman, even though the marriage is out of community of property, then would have property in her name. Are there those, do those instances, do they exist?
There will be such cases where I'll come, if I can come in reply to the question of when the marital property was abolished, marital power was abolished generally. I haven't put my finger on it, but it's in the heads of argument. But there will be those cases where the woman has been stronger financially. And the principle has to be the same, that the spouses in a marriage are treated equally, that they share what they have. That's the starting point or the default position. But there may be cases where there is good reason why the property should be dealt with in another manner. And that's what the order made by the High Court proposes, and which I'd like to explain. I accept that there will be cases which go the other way. So can I, just before I come to that, can I make this submission which I submit is foundational? And that is that these are the only women in South Africa who are subject to this regime. African women married before 1972. For all women who were classified as Indian or colored and white, whenever they were married, the default position was and is in community of property. For all African women in a monogamous customary marriage, whenever they were married, the position now is that the default is marriage in community of property. For all African women in polygamous customary marriages, whenever they were married, the position now is that the default position is marriage in community of property. For all African women who married after 1988, the default position is a marriage in community of property. What we are left with is only this group of South African women who were African women in civil marriages before 1988. They're the only women who have the opposite default position of a marriage out of community of property. And all the sociological evidence shows, and the expert evidence which is before the court shows, that a marriage out of community is generally favorable to the men and generally unfavorable to the women. Not in every case, but that's the general position. And that's why the default has to be a marriage in community for everybody.
Mr. Butlander, the excellent and commendable research done and attached to the papers, is it correct that it suggests 400,000 women are affected?
That is so, Justice Victor. Continuing to be affected, arising from marriages conducted 32 years ago. So we say, as far as remedy is concerned, that the starting point, once there's an invalidity, the starting point is the invalidity goes back to the date of the Constitution. If a pre-constitutional statute is inconsistent with the Constitution, then it has been unconstitutional since the adoption of the Constitution. And that's stated in Ramohovi at paragraph 44. It's the well-known principle of objective invalidity. In both Gumede and Ramohovi, this court made retrospective declarations of invalidity, and the invalidity applied to customary marriages concluded before the commencement of the Recognition Act. In both cases, though, the court made this subject to provisions to ensure that the rights of bona fide third parties were not adversely protected, and to deal with situations where it might work in justice. Can I then go to the order which the High Court made? There is a small confusion in that regard, which we're going to ask the court to rectify. If one goes to the order made by the High Court, perhaps I can start with a notice of motion, volume 1. It's volume 1, page 1. So what we sought in the notice of motion was the declaration of invalidity. 2, it is declared that all marriages concluded out of community of property under section 22(6) of the Black Administration Act are deemed to be marriages in community of property. And then this first protection was provided. Couples who wish to opt out of this position and alter the matrimonial property system applicable to their marriage may do so by executing and registering a notarial contract to this effect. So that's the old protection, would continue to exist to the extent that it's helpful. And then paragraph 3, this is copied from Gumede and Ramahovi. The orders are subject to the following conditions. First, existing burdens on the property now falling into the joint estate as a result of the order remain in place, so third parties aren't prejudiced. And then from the date of the order, Chapter 3 of the Matrimonial Property Act will apply in respect of all marriages that have been converted in community of property under Prayer 2, unless and until the affected couple has opted out in accordance with the procedure set out in Prayer 2. Now, what we did, on reflection, it occurred to us that that safety net provision doesn't deal with a situation of the kind that Justice Cheekley is referring to, where there may be, it may work hardship either way. And so what we proposed to the High Court was that there should also be a provision that a party who's dissatisfied should be able to approach a court and ask for a variation of the property regime. And that really caters for the cases like Mr. Sithole, if he says this works an injustice on him, or a case on a woman who says, well, I've worked hard through the sweat of my brow and the money the assets shouldn't go to my husband. Those people who say that it works injustice would be able to go to court and ask the court to exercise an equitable jurisdiction. And you'll see that the court made that order. The court said at paragraph 3, it's at page 343 of the papers, paragraph 3, a spouse in a marriage which is declared to be a marriage in community of property in terms of paragraph 2 may apply to the High Court for an order that the marriage shall be out of community of property, notwithstanding the provisions of paragraph 2. So it makes it possible for a court to reverse the default in an appropriate case on application by one of the parties. And of course, the other party will be able to come to the court and argue his or her case, and the court can then make a decision. So that we submit that order is appropriate and should remain. But what has been omitted from the order is the paragraph in the notice of motion to which I referred, the paragraph 2 of the notice of motion, which preserves the right to go to court for notarial, preserves the right to enter into a notarial contract. And we submit that paragraph 2 of the notice of motion should be reinserted in the court's order. And then what will be the consequential relief which will follow, paragraph 5 of the High Court's order, we submit should read as follows. Paragraph 5 says, from the date of this order, Chapter 3 of the MPA will apply in respect of all marriages that have been converted to marriages in community of property, unless the affected couple has opted out in accordance with the procedure set out in paragraph 3. So the court did in fact intend to maintain the opt-out position, but dropped it from the order somehow. It would be in accordance, couple has opted out in accordance with the procedure set out in paragraph 3 above, or the High Court has ordered accordingly, has ordered otherwise on application. So there will be two ways of escaping the default regime. One is the existing notarial contract, and the other is an order by a court, which can make an application to adjust cases of injustice on a case-by-case basis.
Through you, Chief Justice, Mr. Butler, without making any promises as to what the outcome will be, I think it's best perhaps for everything to be self-contained to
Yes.
send to the court your proposed order, you know, from paragraph 1 right to the end.
Thank you, Chief Judge. Thank you, Justice Madlanka. We will do that. I'm grateful for the opportunity. We'll obviously copy the other parties.
On that note, Mr. Butlander, paragraph 5 of the order of the High Court
Yes,
refers to the procedures set out in paragraph 3.
yes.
That is in fact not correct.
That's not correct, Justice Tron. That is
Paragraph 3 deals with the position where a spouse approaches the court. It's paragraph 2.
paragraph 2 as the notice of motion. It's got a bit mixed up in the
Yes.
process, Justice Tron.
Yes. So,
With respect, you're absolutely correct. The reference to paragraph 3 is incorrect as it stands.
yes, paragraph 5 should in fact incorporate the rider should relate to unless the affected couple has opted out or a spouse has approached the court. It should cover both eventualities, which it currently
Justice
doesn't do.
Absolutely, Justice Tron. I'm afraid it got lost in the process. That is absolutely so with respect. So those are the orders which we will seek, and I will draft and we'll submit to the court the draft order that we seek, understanding, Justice Madlanka, that no promises have been made in this regard. Then finally, on the question of costs, Mr. Sithole and his attorney have not covered themselves in glory, with great respect, in this matter.
I'm sorry, Mr. Butlander. Before you move to cost, I have one further question on the question of remedy. Practical problem is referred to in paragraph 6 of the order. Any interested person may approach this court or other competent court for a variation in the event of serious administrative or practical problems being experienced. What kind of problems are envisaged?
Well, it's very open-ended, Justice Turan, as you implicitly point out, because one can't anticipate all the situations that may arise, and one doesn't want a party to have to come back to the Constitutional Court to fix them up. It's copied directly from paragraph 59J in the Gumede judgment of this court. And I think, Justice Turan, there was a similar, may have been a similar order which you made in the High Court in the Gumede matter. I can't, my memory doesn't stretch back that far.
Doesn't mean it was correct, Mr. Butlander.
No, it was obviously correct. And, and if it wasn't there, it was because we didn't ask for it. But in Gumede, this court made precisely that order, 59J. Any interested person may approach this court for a variation of this order in the event of serious administrative or practical problems being experienced as a result of this order. One has to recognize with respect that there may be all sorts of problems which could arise. Registration of properties may have to be changed. Documents may have to be reproduced. It may lead to unexpected, unintended consequences. When one rewrites the situation retrospectively, one needs to make some provision, I submit, to deal with cases, individual cases where problems arise. And so,
sorry, Mr. Butlander. So this would take care of where a party has very high debts or liabilities, for example. Yes.
That is so, Justice Victor.
Because that is a concern.
That is a concern.
To take over the liabilities of a delinquent spouse.
Yes, you may. But becoming married in community may be the worst thing possible for you if you have a delinquent spouse. Yes, maybe be better on your own.
I promise this is my last question on remedy. Has it been considered whether the matter should be referred back to Parliament to consider what amendments, what the legislation should reflect, and that this court perhaps make an interim order while Parliament is considering the matter?
Well, the Justice Turan, this court dealt with the matter differently in Gumede and in Ramohovi. In Gumede, the court simply made a declaration of invalidity and struck out the relevant words. But Gumede was a relatively simple case. It was women married in customary marriages. In Ramohovi, the court recognized that once you get into the territory of polygamous marriages, there may be complications or further complications. And I think that's why the court declared a provision, an interim regime. The court in paragraph 4 said, well, the court in paragraph 3 declared the invalidity. In paragraph 4, it suspended the order of invalidity for 24 months to give Parliament an opportunity to correct it. And in paragraph 5, it said in the interim, pending that the interim period, a regime would apply to polygamous customary marriages, which would be in community of property, joint and equal ownership and control of the property. So that option is, with respect, open to the court, but we submit that it's not necessary in this situation because this is more akin to Gumede, where it's one woman, one man, and there's very little risk of the sorts of complexities which arise in polygamous marriages, which Parliament might wish to consider. We submit that the simple remedy of Gumede is more appropriate than the Ramahove remedy. Of course, none of that would stop Parliament, if it wanted to legislate on the matter, from doing so. If Parliament said, we see the judgment of the Constitutional Court in Sithole, and we think the situation should be adjusted further, Parliament is entitled to legislate. It can legislate as it wishes, as long as it does so consistently with the Constitution. So we submit that there's no need for an interim regime. The power remains with Parliament to change the regime if it thinks it appropriate. Chief Justice, if I may then very briefly deal with costs. As I say, the conduct of Mr. Sithole and his attorney unfortunately leaves a lot to be desired. But Ms. Sithole addresses this matter in paragraph 34 of her replying affidavit. She says she's not asking for a costs order against Mr. Dlamini personally. Prospects of pursuing that order don't fill anyone with enthusiasm. And of course, it's a matter for the court. We do say that if the court is minded to indicate its displeasure as to Mr. Dlamini's conduct, then a better way to do it would be to say that he can't enforce any claim for fees arising out of these proceedings. The court does that from time to time, but that's a matter in the...
Well, Mr. Butlander, I got a sense that, Mr. Butlander,
Yes, Justice.
I got a sense that a sense that your client's attitude is we're not really supportive of that line, but if you so mind that we can't stop you.
That is so, Chief Justice. We're not proposing it. We're saying if the court wishes to do something, that's an alternative route, but we're not asking for it. What we do ask for is, consistently with the decisions of this court in Rahube and in Levenstein, perhaps I can give the court the references. Rahube is, I think, cited in our heads of argument. It's 2019, 2 SA 54, Constitutional Court, paragraph 72 and 73. And then the Levenstein case, Levenstein versus Estate Frankel, 2018, 8, Butterworth's Constitutional Reports, BCLR 921 CC, para 79, where in both cases the court expressed the principle that if legislation is found to be invalid, the responsible minister is responsible for the costs of obtaining a declaration of invalidity. And so we ask on that principle that the same should be followed. Chief Justice, unless there's anything further, those are our submissions.
Thank you very much, Mr. Butlander. Ms. Badad.
Chief Justice, Justices, the first respondent accepts the applicant's submissions that Section 21(2)(a) of the Matrimonial Property Act perpetuates the discrimination caused by Section 22(6) of the Black Administration Act, because it maintains that marriages, because the Black Administration Act, Section 22, maintains that marriages of Black persons entered into before 1988 are by default out of community of property, while all other marriages in South Africa are in community of property by default. The first respondent therefore agrees with the remedy proposed by the Durban High Court, that which is that all of those marriages concluded in terms of the Black Administration Act before 1988, that those marriages should be now declared to be in community of property. However, the first respondent's contention, the reason for his opposition is, or the first respondent's opposition to the order is that his and the first applicant's marriage is not one of those that fall into the category which we agree is unconstitutional. The first respondent states that his and the first applicant's marriage was by choice. They are married in community of property, but their marriage was not a dictate of the Black Administration Act. They chose knowingly, understanding the consequences of a marriage in community of out of community of property, and that is that is the marital property regime that they agreed to at the time, and it is what they wanted. They did not want a combining of their assets, and that is the marriage that they entered into. So the first respondent's overarching contention is that their marriage shouldn't be imposed the remedy of the Durban High Court, which is that their marriage should be converted to a marriage in community of property, because their marriage was not enforced on them, as was probably the case in all of those 400,000 other marriages which the applicants have referred to. And the first respondent therefore requires that this court be cognizant of that difference in their marriage. Just to illustrate the point or to confirm or to give evidence to the point that it is indeed not as the first applicant submitted in her affidavit, that the only marital property regime that was available to them at the time that they got married was one out of community of property. The first respondent had procured a confirmatory affidavit from Father Ndabe, who is a priest at the Roman Catholic Church. It's the church in which the couple had gotten married in 1972. And it is in this affidavit where Father Ndabe confirms that the various marital property regimes which were available to prospective married couples at the time, classes were given to those couples, and they were informed about the different marital property regimes. And therefore, when they made a decision to be married in community of property, out of community of property rather, in the first respondent and the first applicant's marriage, that they'd made an informed decision and voluntarily chose the marriage out of community of property. The first, the first respondent therefore humbly requests that the court allow admission of this confirmatory affidavit by Father Ndabe, because it's in the interest of justice. It confirms what the first respondent's contentions are, that they made an informed choice, that the out of community of property, marital property regime was not forced on them. And Father Ndabe's affidavit obviously confirms that the marital classes do take place, that they do include lessons on the various marital property regimes that were available for prospective married people to choose from, and that the church would not dictate to the prospective married couple which marital property regime to enter into. So definitely, and the affidavit confirms that the marital couple, the couple would voluntarily choose which marital property regime they wanted to enter into. So therefore, again, we seek admission of the affidavit by Father Ndabe, because it confirms that this marriage of the first applicant and the first respondent is not a marriage in which the outer community of property was enforced on the couple, which would make it then unconstitutional and then therefore subject to being changed into a marriage in community of property by the order of the Durban High Court. The first respondent would also submit that to impose the out of community, to impose the community of property, marital property regime on their marriage would be just as draconian, as harsh as having enforced or having unfairly made all of those marriages before 1988 in terms of the BAA, would have made all of, would make enforcing that their marriage is one in community of property would make that unfair. And therefore the court is asked to be cognizant of the distinction of their marriage compared to those others and accordingly make its order. The first respondent, to substantiate his version, which is not what the first applicant has said, the first applicant had stated that the only marital property regime available to them at the time was one out of community of property, and that she was told that by the official marriage official at the church. The first respondent rejects that version, as I've stated before, and reiterates that there were always options available to them through the marriage classes. They were properly informed about that. The first respondent therefore makes a suggestion that though we do understand, or we do agree that the order of the Durban High Court is a remedy to the unfair discrimination caused by Section 22.6, but that perhaps that order would better be varied, that order 2 rather of the Durban High Court would better be varied to state the following. All marriages of Black persons concluded out of community of property under Section 22.6 of the BAA before 1988 be and are hereby declared to be marriages in community of property, except if the parties had voluntarily concluded a marriage out of community of property. So that's the proposal by the first respondent to as a suggestion of how to deal with the fact that their marriage is not a marriage which was forced on them, or an out of community property of marriage which was forced on them, because that's not his contention. The first respondent says they willfully chose the marital property regime of out of community of property. They had no intention of having a joint or combined estate and that the first applicant, that Ms. Sithole, had agreed thereto at the time of their marriage.
Well, your 10 minutes has expired, Ms. Badat. So as you proceed, expect questions from my colleagues if they have questions.
As the court pleases, Chief Justice.
Okay.
Ms. Badat,
Ms. Badat,
what is different? Let's look at clause 3 or order 3 of the High Court. And maybe if you can, that's at volume 4, page 343.
I'm there. Would you like me to read it, Justice?
Can you address me on that and tell me if there's any difference, if the respondent is not protected by that clause?
Justice Mantla, why that is different to what the first respondent's proposal is because Order 3 requires that the party, one of the parties, the spouse, who is dissatisfied with the default that was ordered by the Durban High Court, that they would have to go to court to have that marital property regime changed back to one that they had voluntarily chosen. So what the first respondent's proposal is that the Order 2 should be amended to include the scenario, or not to include, to accept those marriages where the out-of-community property marital property regime was voluntarily chosen, because that would make the requirement that he now has to approach a court for that order to change his marital property regime back into one out of community of property. When him and the first applicant had chosen that marital property regime. So that's the difference. Order 3 requires that he approaches a court to make his marital property regime what they had chosen in the first place, whereas his proposal that Order 2 be amended to say, except if the parties had voluntarily concluded a marriage out of community of property.
Now,
he doesn't
what
have to go back.
Ms.
He doesn't
Badat,
need to go to a court to have his marital property regime remain a marriage out of community of property.
excuse me, Ms. Badat. The submission upon which you rely, that the parties voluntarily chose to be married in community of property, firstly, is the say-so of the first respondent, and secondly, the affidavit by Pastor Ndabe. The parties, I just need your clarification. The parties were married somewhere in 1972, and Pastor Ndabe was ordained as a Catholic priest in 1989, sorry. It does not seem to me that he has personal knowledge of what transpired in 1972 when they were married. He is testifying in this affidavit by what he says would have been the procedure at that time as it is practiced in the Catholic Church. And that's a factual inquiry. And you are asking us to accept and vary the order of the High Court to include the insertion that except where parties had voluntarily agreed based on this affidavit, which one has problems with its admissibility, two, it's a witness who's testifying about what he thinks was the procedure at that time, who has no personal knowledge thereof. And you have to weigh that vis-a-vis the evidence of Mrs. Sithole. And as it was correctly put during the argument,
of Mr. Butlander, how they were married, it's irrelevant. And what they said, these are confirmation proceedings. We're looking at as you correctly accepted, that the order of the High Court is unassailable. I seem to get lost somewhere with your argument on the insistence that we should focus intently our attention on the affidavit.
Justice Motopo, the reason for my submission is that these proceedings are to confirm the order of the Durban High Court. And the first respondent, while I've already confirmed that he accepts that he's not disputing, rather that the Section 21(2)(a) of the Matrimonial Property Act is indeed discriminatory, and he accepts that solution and remedy is to make those marriages which were by default out of community of property, to make those in community of property. The first respondent's submission, though, is that his marriage simply as I can put it, his marriage with the first applicant is not one of those marriages. It is not a marriage that had been forced on them by the BAA. They chose, they understood that there were options to them, because at the time, they didn't comply with the default marital property regime of out of community of property. They made an informed decision to enter into a marriage out of community of property. And so that's...
But can I just ask something? Did they then mislead FNB when they were applying for the home loan agreement in saying that their marriage was in community of property? If you go to page 32, Mrs. Sithole asked, they signed there in that home loan agreement. And below her signature, it says consent of spouse if married in community of property.
Justice Tiki, what I do know is, notwithstanding that signed home loan application form, that the home that they had applied for is registered only in the first respondent's name.
When I saw this, I thought that maybe what Mrs. Sithole is saying about them not really knowing what their marital regime was should be given credence. But I'm just saying.
May I just answer on that, Justice Chiki? If you look at Ms. Sithole's founding affidavit at paragraph 12, she actually says, I'll just read quickly. It says, at the time of our marriage, the officiating priest told us that marrying out of community of property was the only option available to us as Black persons. She goes on to add to that, but she admits herein that they got married out of community of property. And that obviously contradicts what she had said thereafter, that she assumed that they were, or her understanding was that they were married in community of property. But she does make the submission at paragraph 12 of her founding affidavit that at the time of her marriage, the priest told them that the only marriage available to them was one out of community of property. And as I've confirmed, the first respondent rejects that. He says that the marital classes that that the Roman Catholic Church required of them because they were going to get married there, told them about the various marital property regimes available to them, and that they made an informed decision.
Ms. Badat?
Yes, Justice Theron.
I'm sorry to interrupt you. Are we not conflating two issues? What we are dealing with now, as I understand it, is the validity, the constitutional validity of the section. At this stage, we are not dealing with, or we're dealing with the default position. The second part would be if either Mr. Sithole or Mrs. Sithole wants to change the default position which the High Court has set in place in the event that this court confirms it. Wouldn't that be for another forum to deal with and not this court? What we are dealing with is the constitutional invalidity, if any, and the consequences that flow from that. And those consequences should be applied generally. And we're not dealing with the case-by-case application of whatever decision we make today or eventually in this matter.
I appreciate
and that is why the High Court made the provisos in paragraph 1, in paragraph 3 and paragraph 5 of the order. So after this court has determined this issue, if we confirm the order that the High Court has made, any party then, any spouse or any couple may approach the court for consequential relief.
I understand that, Justice Theron. The first respondent's opposition is because this is an application before the Constitutional Court for confirmation of the constitutional invalidity. But we are now in a position where we can place before the Constitutional Court a scenario that is not part of the blanket decision which is relevant to the constitutional invalidity of that act, of Section 21(2)(a) of the Matrimonial Property Act. And it's just something that we would want the court to be cognizant of. Not that we did not understand that order number 3 of the Durban High Court's order makes provisions for a party or a spouse to approach the High Court for an order that the marriage remains out of community property. We appreciated that. We are saying that that still required that the first respondent would have to go to court to get that order for a marriage that him and the first applicant had agreed would be out of community of property.
That is an aspect, Ms. Badat, which would need to be fully ventilated and both parties place their evidence before the court. My question only is this the appropriate forum? Isn't it the incorrect forum for that?
I'm in the court's hands. I take your point, Justice Theron. I just have made the submissions because the first respondent's marriage is not one that was subject to the discriminatory law of Section 21(2)(a) or Section 22(6) of the Black Administration Act as perpetuated by Section 21(2)(a) of the Matrimonial Property Act. But I take the point, and I'm willing to move on from that.
Before you move on,
Yes,
Ms.
and it seems to on the very order. Thank you, my brother. On the very order proposed by the first respondent, a party would still need to go to court because the order proposed by the first respondent says, unless the couple would have chosen a marriage out of community of property. In order for that determination to be made, the parties would need to go to court and lead the evidence because it's not clear on that order as it stands. How would people know which marriages have been converted into community of property or not unless there's an order from court? So on the face of it, it seems what the first respondent is proposing is exactly what is contained in the High Court order, unless I'm missing something. It's not going to be automatic that any particular marriage is going to be declared in community or sorry, out of community or property. The formulation proposed by the first respondent allows a party to not to have the default position.
I see that point, Justice Ram, that you're making, that there would still be a need for a court to intervene to confirm that that marriage is out of community of property. I can see that there would be no way other than a court order. And that is provided for in order number 3 of the Durban High Court's order.
Ms. Badat, can I just add to that? It goes further than that. You see, you complain that the first respondent is being compelled to go back to the High Court. And as my sister has explained to you, that is in any event inevitable. But it goes further than that. You see, the first respondent avers that this marriage is broken down irretrievably and that a divorce is inevitable. So what that means is that he must go to court anyway to get a decree of divorce. And the Divorce Act permits him to ask for an order that the assets of the estate should be divided as if the marriage were married out of community of property. So he has to go to court anyway for a divorce, and he can ask for such an order. So what's the problem?
Justice Majid, I understand your point. I think it's just that if the Durban High Court order is confirmed that all of these marriages are now in community of property, Section 7.3 of the Divorce Act will no longer come to their rescue, to the first respondent's rescue, because it deals specifically with an out of community of property marriage, which is in terms of the Black Administration Act, Section 22(6) of the Black Administration Act.
No. If the High Court orders of invalidity is confirmed, then all marriages such as this one are deemed to be in community of property. And if your client insists that this was supposed to be a marriage out of community of property by consent, by choice, by agreement, then he can go to the divorce court and persuade them to make such an order that it should be declared. He asks for a declarator in terms of the section that the marriage be declared to be out of community of property on the facts that he would advance there. That's the point I'm making, isn't it?
I accept that. Justice Majid, I do accept that. Because what is Justice Ron had just confirmed, and I submitted that it is a fact that he would still need to approach a court for the order that he seeks to be confirmed as out of community, that his marriage is out of community of property.
Ms. Badat, I want to assume that the first respondent is not opposed to the confirmation of the constitutional invalidity on the basis that the law differentiates, Section 22, subsection 6 differentiates between men and women and between Black people and other people. Would I be correct in my assumption?
You're 100%. You're 100% correct, Justice Kampepe. The first respondent does not deny that it is unconstitutional. The first respondent does not deny that Section 21(2)(a) of the Matrimonial Property Act perpetuates the discrimination caused by Section 22(6) of the Black Administration Act. It is unconstitutional.
Thank you.
Ms. Badat, are you ready to talk about costs?
Indeed, my Lord, Justice Majid, if I could just...
Sorry, can I just ask you this? On what basis does Mr. Sithole persist in this denial that he was ever served with these papers, when we know that the sheriff served on him personally on the 26th of April 2019? Or is that part of the conspiracy, the secret conspiracy? Do you accept that there's been personal service?
Justice Majid, I can do away with this secret application submission, past submission of the first respondent. We've abandoned that. I took instruction on that. I explained to, my instructions are simply this. It is evident that because the matter was defended at the Durban High Court and that the matter is now, or rather opposed at the Durban High Court, and that submissions were made and that there was counsel who was briefed to appear in the matter at the Durban High Court, and that the matter is now, that the first respondent is now represented and that the matter is being opposed on his behalf, and his view is being placed before the court, or his submissions are being placed before the court, that the secret application or the secret, what is the word that he used? That the Durban High Court matter was brought in secret. We've abandoned that. We don't want to pursue that argument at all. It's not necessary.
But Ms. Badat, the attorney is also guilty of this to an extent, Mr. Dlamini. You can't make these kinds of allegations on oath in papers in a court, in any court, and cast aspersions on an attorney. I'm talking of the lady of the LRC, an attorney who's gone to great lengths to ensure that Mr. Sithole gets notice of this. She wrote letters to him. She went to great lengths, as I say, to make sure that he gets knowledge of these proceedings. And it's actually, as she says in the affidavit, it's defamatory of her.
Justice Majid, I know that the perception by the first respondent of this application brought in secret to the High Court for a change in the marital property regime it stems from the fact that the parties currently still stay in the same house. The first of the parties, the first applicant and the first respondent currently still reside in the same house, and she had never informed him of the fact that this matter had been set down in the High Court. Now that, I agree, does not change the fact that he was served through his attorney with the papers, and in fact, I think it was served on him personally, on the first respondent. The application to the Durban High Court was served on him personally, the first respondent, as well as on his attorneys. But as I said, Justice Majid, the first respondent has since abandoned the contention that this matter has been brought in secret for the very obvious reason that the matter was opposed in court with counsel, and that the matter is now opposed with counsel, and therefore it cannot be perceived, cannot be said that the matter was.
Yeah, well, we've covered that ground before. Let's move on. All I want to ask you is this: Ms. Sithole says through her counsel, Mr. Butlander, that she's not interested in pursuing a cost order against Mr. Dlamini, the attorney. But you must motivate why we shouldn't make an order that he be deprived of his costs in this application on the basis advanced in the papers.
I can make the following submissions on his behalf. Justice Majid, you would have seen the affidavits that he submitted in defense to the proposal that he pay the cost, the bonus proprius, and also now that you're saying the proposal from the first applicant is that he pay, from the applicants rather, is that he pays, that he not be able to bill for.
Sorry to interrupt you, Ms. Badat. Ms. Badat,
Yes,
has Mr. Dlamini deposed to an affidavit in respect of the costs?
He has,
Justice Ron. In respect of the order that this court issued the last time that he should show cause?
He has indeed. I've got it with me. If you'd like me to read it to you, or how would you like me to? It was submitted to the correspondence attorneys for submission to this court, to the Constitutional Court, Justice Theron. The affidavit from this court.
Ms. Badat, please could you repeat that? It was submitted to.
It was
Sorry,
the
what is the date of the affidavit?
Monday was the. So the first affidavit, Justice Theron, was per the court's direction, the 23rd of September. The court's direction, the Constitutional Court's direction, was by the 23rd of September 2020, Mr. Dlamini had to submit an affidavit to say why a cost order bonus proprius was not to be made against him. He had complied with that in time. He had, however, mistakenly written, it was like a typo, where he had said that the cost order shouldn't be made against the first respondent. And he corrected that in a like a supplementary type affidavit that he submitted yesterday, Monday, the 28th of September, where he just says he'd made a mistake. He'd used the words, or rather that he'd stated that the cost order was sought against the first respondent, but he understands that cost order was the bonus, what he said in his
Sorry, there's a problem with the sound.
David, I'm happy to put that before the court. If you've not, as you've not seen it.
I couldn't hear
Well,
that.
while we are there, Ms. Badat, while we are there, what he doesn't do though, was explain why, knowing that he was in the habit of changing his email address from time to time, by reason of his phobia about technology, why he did not inform his counterparts every time he changed his email address. He also does not explain in that affidavit why he did not respond to the many emails and other communications which appear to have reached him. He also does not explain why he did not file an answering affidavit in this court, despite repeated requests by his counterpart to do so. He doesn't deal with that.
Okay, Chief Justice, I can make these submissions on his behalf from the affidavit. He does indeed, at paragraph 2 of his affidavit, he states—
How does he deal with, what does he say about his repeated change of email addresses and why his counterparts were not notified? What does he say?
Okay, this is what he says. At paragraph 4 of his affidavit, he says, I place on record that my email address being B. Dlamini attorneys had changed, but my failure to have updated all practitioners I deal with, and in particular the LRC, should not be held against me, for in this case, our effective way of service was and had been the nature of personal service. He had not—
No, that doesn't quite answer that question. Remember, it was necessary because you are the one who told us on the 17th that the man had a phobia. So why didn't he tell the LRC in particular against whom he was litigating about the change of email addresses? Why?
His rationale or his reason is this: he had lost his phones, Chief Justice. He says this on paragraph 2. He had lost his phones that he uses to get his email addresses. He was using his daughter's cell phone, and she had
for business. He was he was using his daughter's cell phone for business matters.
He had lost his cell phone, his submission. And Chief Justice, can we keep in mind though that this is during the time of lockdown? It was hard lockdown at the time. He does not make that submission, but I mean, I'm not sure if the court will allow this, but it is a fact that at this time, it was hard lockdown. So he would not have had an opportunity to go and replace his phone at the time. And he would have, not that he makes, again, like I said, he hadn't made those submissions, but it is a fact that it was lockdown as it around the 30th of hard lockdown, around the 30th of April 2020, he hadn't had a chance to replace his phone. He was using his daughter's phone, and that is the phone to which any email that had been sent to him would have been received. She did not pass on any messages to him. This is his version. And so he was comforted also by the fact that the parties had agreed with he's saying with the LRC himself as the attorney of the first respondent, had agreed with the LRC's attorney or attorneys or representatives, that the matter would be heard in open court. Chief Justice, if one has regard to the fact that it was hard lockdown, we are in a pandemic, the fact that an open court hearing had been agreed between the parties, he was anticipating a hearing date well into the future, so he was not on the alert for any notice of set down to come to him. And so he had anticipated that if that notice of set down had been dispatched to him, it would have been done so by physical mail, because that is how all other notices and correspondences from his counterparts had come to him before, physically delivered to him. That is what also evidence of, or rather, it explains why he wasn't too focused on updating an email address.
Well, that may well be a good reason, but I don't understand why, especially because it was during lockdown. He would expect a physical delivery. All the more reason for him to expect, documents to be sent to him via email, and one would then have expected of him to share his email, even from his daughter's phone, with the LRC. But I obviously haven't taken any position either ways. The explanation may well be reasonable. He may have mistakenly thought this way when in fact the reality pointed to a different approach. I just need a clarification on that, but I hear you.
Chief Justice, may I just make the submission as well? In my brief that the attorney delivered to me, he had handed me an actual, which I've scanned into myself because I think it's relevant, the waybill of the door-to-door delivery courier service, where the opposing affidavit of the first respondent had been couriered, as well as the replying affidavit had been couriered to the correspondent attorneys on the 12th of March 2020. I scanned it in. I'm happy to send it to the court. It is proof that he had submitted his the first respondent's answering affidavit when he said he did. When I was before this court on the 17th of September, I had phoned Mr. Dlamini, and he told me that verbally, and this is the proof. As I said, I've scanned it in, I've got it here in front of me now as well, that he had actually delivered the opposing affidavit or answering affidavit and the replying affidavit to his correspondence attorney, telling them that this needed to be filed with the court. That wasn't done. I hadn't pursued understanding from the correspondent attorneys why they hadn't filed it, but this is proof that he had sent it to them and told them to file it with the court. There's also, he'd also, which I have before me as well, and I've scanned in a copy, sent me a copy of the letter on his letterhead that he sent to the correspondent attorneys, and it's dated February.
Excuse me, Ms. Badat.
Justice Matopo.
You are now giving evidence. That's not admissible.
Noted.
Should have been in your papers. It's not, but you're now giving evidence.
You see, Ms. Badat, I don't know why that correspondent attorney was not even asked to file an affidavit in view of what transpired on the 17th. Mr. Dlamini could simply have picked up a phone and said, look, this is what transpired on the 17th. The affidavit has been ready since March, as you know. Deposed to an affidavit explaining what happened. Now, we don't even have that correspondent attorney's affidavit now, explaining why an already settled affidavit was not filed.
Noted, Chief Justice.
Any other thing? Yes.
Ms. Bharat, before you conclude, through you, Chief Justice.
Yes, my sister.
Mr. Dlamini did receive a record in this matter. That is correct, yes?
A record as in, I'm sorry, Chief Justice Theron?
Well, the record comprising, is it 4 volumes? The record in this matter, in the Sithole matter that we're dealing with.
Justice Theron, can I just say what I do? I have. When I consulted with Mr. Dlamini, he handed me a bundle, and honestly, the bundle was not paginated, which I would have thought would have been the record.
Yes, part of that bundle contains directions, should contain directions issued by this court, dated 28th of February 2020, advising the parties that the matter was set down for hearing on 12 May 2020.
Justice Theron, honestly, I have not seen that direction from the court. It's not, and I stand to be corrected, I have not had sight of that in the bundle.
Yes, and Mr. Dlamini should have had sight of those directions. There is no explanation from Mr. Dlamini. Firstly, if he did have sight of those directions, why he failed to act, or secondly, that he did not have sight of those directions. This is the difficulty we have in this matter, Ms. Badat. There is not a full explanation before this court, and that is what the Chief Justice was putting to you earlier as well.
Justice Theron, I have made every submission that I can from the information given to me, and as Justice Motopo had pointed out, I even gave evidence that was not in his affidavit from what he's told me and what he's given to me in order to place as much information in his defense really before the court. I'm in the court's hands.
Thank you, Chief Justice.
Thank you, my sister. Any other submission, Ms. Badat?
Chief Justice,
Can I take it that you have no further submissions to make, or do you have?
Chief Justice, if I may just have one moment, please. I just want to make sure that I haven't missed any point. I did have a point here, and I'm only reiterating what has already been confirmed, that the Durban High Court did not declare Section 21(1) of the MPA unconstitutional, which is what one of the submissions that the applicants' heads of arguments made. I mean, but that had been dealt with. It's a note that I'd made as well. Chief Justice, thank you for your indulgence. I have no further submissions.
Thank you very much, Ms. Badat. Thank you. Mr. Butlander?
Thank you, Chief Justice. I'll be brief. 5 brief points. Firstly, Justice Chiki asked me about the
Butler,
DV.
it's your turn.
Can you hear me now, Chief Justice? I think some members of the court are hearing me, but not others.
Chief Justice, are you able to hear Mr. Butler? It seems that the Chief Justice has momentarily lost connection, Justice Kampepe.
Yes, Mr. Butler, you may proceed with your reply.
Thank you, Justice Kampepe. So 5 brief points. Firstly, as to the reference to DVB Behuising, the reference is DVB Behuising versus Northwest Provincial Government. And the reference is 2001, Volume 1, SA, page 500, Constitutional Court, and the passage in question is at paragraph 1, the opening paragraph. Secondly, as to the abolition of the marital power, it's addressed in paragraph 54 of our heads of argument. It was abolished by the General Law Amendment Act 132 of 1993. So up till that time, the marital power continued in existence for some women, including people such as Ms. Sithole. Thirdly, as to the relief suggested by Mr. Sithole, I think that's been dealt with by Justice Taron and Justice Majid. But I simply point out it's dealt with in Ms. Sithole's replying affidavit filed this past week at paragraph 29. She points out that if Mr. Sithole wants to sell the house and he goes to a buyer, assume the order made by Mr. Sithole is made by this court. The order proposed by him is made by this court. If Mr. Sithole then goes along to a would-be buyer and says, I'd like to sell you my house, and I can sell it to you directly because I'm married out of community of property, because that's what my wife and I agreed at the time, the seller will not know whether he has competence. And if it believes what he says, then it'll buy the property will be transferred, and Mr. Sithole will be dispossessed and left homeless. And the uncertainty created by an order which says, well, if this happened, without saying any means of how you decide whether it's happened, is with respect quite self-evident. One can't have a situation where there are 400,000 women and 400,000 men are wandering around, and no one knows what their marital property regime is. In respect of all those 800,000, no one will know, and even they won't know what their marital property regime is. That is a fantastic recipe for uncertainty and chaos. Then the fourth point, as to the point raised about the visit to the bank, Ms. Sithole has explained the sequence of events. She says, it's in paragraph 17 to 20 of her affidavit. I'm not going to take the court there. But what she says is the following. She says, when we were married, I was told that I had no option but a marriage out of community of property. In the late 1980s, there was talk in the township, and I heard that there was a change to the marital property regime. And I thought it meant that I was now married in community of property. That's obviously a reference to the Amendment Act of 1988. She says, I thought I was married in community of property, and I was then very happy about that. And she says, then we went along in 2000 to buy our house. And I signed that I was married in community of property. And in fact, she says her husband also told the bank that they were married in community of property. So her affidavit is entirely consistent with what she said at the outset, which is they were told they had no option. She heard in the late 1980s that it was a change in the law. She thought it was then in community. And when they went along to the bank, both she and he said, we're married in community, and she signed saying that she was married in community. So there can be no doubt about that. Finally, on the question of the conduct of Mr. Dlamini, I have tried not to not to say too much about that because it's really a matter for the court. And I don't want to rub salt into the wound. But I do want to say this, justices, that it's really not good enough for my learned friend to say he now abandons the point of secrecy. You can't make a defamatory allegation and then say, oh, I'm not taking that point anymore, without saying, actually, the defamatory allegation was wrong and I withdraw it and I apologize for it. What Mr. Dlamini and Mr. Sithole do is they put up not a word of apology, not a word of withdrawal for an allegation which was defamatory, it was false, and it was in fact scandalous. And then to stand up in court and say, oh, I'm not pursuing this point is fine for counsel, but it's not fine for them. And I submit that it would be, I'm not asking the court to say anything about it, but it would be nice if Mr. Dlamini is the officer of the court and if Mr. Sithole would say, apologize to Ms. Samuel for the scandalous things that they said about her under oath and withdraw them and say they were wrong. We're waiting for any sign of that. All Mr. Dlamini says is he's done nothing wrong, and Mr. Sithole says he's done nothing wrong. That's with respect not acceptable. Chief Justice, those are our submissions.
Thank you, Mr. Bartlander. Judgment is reserved and court adjourns.
As the court please.
Today's proceedings have concluded. The host will now terminate the hearing.
Thank you.